Government legal offices, lawyers, tend to be one of the most frequent and cited roadblocks for those using other transactions. As a former general counsel at DARPA, you have a unique perspective. What do you think are the important qualities for a government lawyer on an OT team?
Other transactions are legal authorities. We work with three principal statutes, I would say: 10 U.S.C. 2371, Science and Technology OTs, 10 U.S.C. 2371b, Prototype OTs, and 2373, Procurement for Experimental Purposes. And I might also mention Prize Authority 2374a, but the point is, in other transactions, the authority is stated in those statutes. There's no gloss of regulation like there is with the federal acquisition regulation, where you turn to the regulation and you may not even look at the statute. The DoD guide on other transactions says it is just that. It's a guide. So the touchstone in dealing with other transactions is to understand the statutes. And attorneys are trained to understand, to interpret statutes. One of the problems in attorneys dealing with something new, something like other transactions, is that they tend to apply preconceived notions to what the statutes might mean. For example, 10 U.S.C. 2371, as originally enacted, was specific to DARPA. So what was authorized by 10 U.S.C. 2371 was advanced research projects. Well, what do those words mean? Advanced research projects in the original statute basically meant the kinds of things DARPA does. What were those? Well, DARPA did things like basic, applied, and advanced research, but it also did interesting things like, under Project Agile in the Vietnam era, before there were OTs, DARPA purchased 1,000 off-the-shelf rifles. DARPA shipped those rifles halfway around the world to Vietnam, and they were used in a test program with Vietnamese soldiers and American Rangers for a year. And the result of that purchasing off-the-shelf weapons, shipping weapons, running a test program, was done, and it revolutionized the Army's approach to small arms weapons, because that rifle, that commercially available AR-15, and that test program led in directly to the development of the M16, which became the standard infantry weapon of the Army. So the breadth and scope of what that basic statute, 10 U.S.C. 2371, meant could be understood, but it was not necessarily evident to everyone. So the statute was reenacted, and the language was changed to basic, applied, and advanced research. What was the reason for that? Well, there were folks that thought advanced research projects might not be understood by the DoD community as including basic and advanced research, because the kind of organizations, laboratories that do basic and advanced research are not necessarily the kinds of organizations that do basic and applied research, are not necessarily the kinds of organizations that do advanced research that lead directly into major acquisition programs. Well, there were lawyers in the department that looked at that language, basic, applied, and advanced research, and said, oh, that means the same thing that those terms mean in the Financial Management Manual, 7014R, point 14R. Well, no, the statute has its own independent meaning, and it's not dependent on a regulation, whether it's the Federal Acquisition Regulation or the Financial Management Regulation. And attorneys, when they're dealing with these statutes, have to be willing to dig down into the legislative history of the statutes in order to discern their real meaning. And what attorneys did in this one particular case was they looked at basic, applied, and advanced research, in 10 U.S.C. 2371 and reached the conclusion you can only use research, development, test, and evaluation appropriations if you're executing under a 2371 agreement. And then they looked at 2371B, and it says this statute is executed under the authority of 10 U.S.C. 2371. Therefore, they further reached the conclusion you could only use RDT&E appropriations for prototype projects. Well, this is a completely misguided view of the authority that's available under those statutes. And the current DoD guide, which was issued in 2018, says very clearly the appropriation that should be applied to a project is independent of the contracting instrument that is used. And in fact, OT projects have been funded by RDT&E appropriations, procurement appropriations, O&M, operations and maintenance appropriations, as well as Defense Production Act Title III funds. And I mean, it's just a normal fiscal law analysis. But when attorneys come to the table, they come to the issue, and they're thinking in preconceived notions, preconceived intellectual boxes. They don't fully elucidate the authority and the power of the OT statutes, and that can be a real stumbling block because lawyers, rather than being yes/no gatekeepers, can potentially be enablers that help people to understand the real scope of the statutes and how they can be used. And that requires digging down into the legislative history, digging down into the intent. It requires understanding the spirit of other transactions as well as the legal language that they're conveying in the sterile words on a sheet of paper. Other transactions are statutes that were enacted in order to cure something. There was a problem that they're dealing with, and the problem was the traditional acquisition system, the cost too much, takes too long system, the highly regulated purchasing system. Other transactions are not supposed to be that. And if you bring a mindset that brings concepts from that traditional system into OTs, you'll be missing the bet. And lawyers have the potential to understand and liberate folks thinking about other transactions, or they can end up in that gatekeeper, yes, no, mostly no type of tradition and clog up the system and keep needed things from happening. So there's a great opportunity for lawyers, and professionally, it's very rewarding to be part of crafting a solution and have a key role in strategy and project development. Unfortunately, and not all of our DoD attorneys see that as the role they want to participate in. And also being a member of the team and respecting the opinions and the education and the experience of other team members and bringing that as part of what you do in strategizing on an OT can only enhance the lawyer's role.
If you're a government lawyer with interest in OTs, Rick Dunn assuredly wants to talk to you, and he can be contacted at strategicinstitute.org.